So welcome back, Ilana. Thank you so much for joining me once again.
Excellent. Thank you, Tasneem. It's wonderful to see you guys again. And wow, we are in December. Can you guys believe that? End of the year.
It's crazy. But even just like I was telling you earlier today, like from week to week, I didn't even dare, like Wednesday just crept up on me again. I was like, oh my God, it's Wednesday again. I didn't even touch base with Ilana to find out what's happening this afternoon because it just kind of came around so quickly.
Now that's a good working relationship, so don't worry about that.
Okay, so today we're going to be continuing, wrapping up the third part of the series where you mentioned you wanted to speak a little bit more about the tax implication of the different types of registrations or company types of companies, and then what you need to consider when wrapping up a company if you want to close your practice or sell your practice.
Excellent. Yes, totally right. So we said that we want to touch base on contracts and what you need to consider with that. So I've actually asked Armand from our offices to join us this afternoon. So as soon as he's joined us, I will ask him to step in. But I think then we'll probably go into touching a little bit about the tax implications or the tax benefits for being a sole prop versus being a company. And I've once again done some slides for you guys. So I think maybe if I can share that with you, that would be awesome.
Okay, let me bring that up. There we go.
Excellent. So, as I mentioned to you before, it's going to be a little bit about contracts and agreements, the tax implications, and then also what happens if you want to close down your organization or just wind it up. So let's run through that quickly. So I'm going to just skip past the shareholders agreement. We'll come back to that as soon as Armand has joined us. So, firstly, what you need to consider between a sole prop and an Inc. is the tax. So, obviously, as you guys can see, you can basically, as a sole prop, be taxed on 18%. That is your base amount that you will be taxed on. And that can actually vary up to 40% because you are being taxed on your individual tax tables. So, SARS has a tax table that they would indicate if you fall into a specific bracket, what that percentage would be that you will be taxed on. You can still deduct certain expenses in your sole prop, so certain expenses that you have for your business, being it cell phone expenses, telephones, things like that. You will still be able to deduct from your sole proprietor. And then also from a financial side, you can have a financial compilation for your financial statements being drawn up in this organization. And then I asked Jack, that is doing our tax at the moment, approximately what is the cost that we are looking at. And he confirmed for me setting up the financials for a sole proprietor should cost you anything from 4,500 to 6,500 to be drawn up. Once again, that would depend on the amount of transactions going through. But that's looking at the sole proprietor. Then obviously we're looking at the incorporated company, and there you are looking at basically a fixed rate of 28% that's raised on the companies. Once again, you're going to have a salary deduction probably for yourself, and that will once again fall into the individual tax bracket. But the nice thing that you can consider is actually having an assessed loss. I don't know, Tasneem, if you know what that means or what the implication of that is.
No, I don't know what that is, but I was gonna ask if it's possible to like sort of set it so that if, especially if you are the only person working in your Inc., if you your salary so that your Inc. Doesn't make a profit, so that it doesn't pay tax, and then you still pay on the personal tax rate your salary for your salary only, if that's possible. So I don't know if that's kind of what you're talking about with the assessed
Exactly. Yeah, so the assessed loss is slightly different. So assessed loss would be that, say for instance, you've got a certain amount of expenses for a specific year, and that actually exceeds the profit that you are making. That means that for actually, if you're looking at the financial year, you've made a loss. And that loss can be carried over from one year to another. So that's actually meaning that you're starting with a minus when you look at your tax. So definitely you can have your salary as an expense in the business, and obviously then just be paying the salary in terms of your personal income tax. So that could be a nice expense. But the assessed loss is actually, like, say for instance, you buy some equipment or had a huge expense in the company. You can actually carry that over from one year to another, so that you basically maybe start the business in a minus 50,000 before you start incurring a tax for the specific year. So that's something that's quite nice in terms of expenses in the incorporated company. Then the other thing that you
Okay.
need to
So just to clarify, so say if in my practice this year I made a loss of 10,000 Rand, then that
correct,
10,000 Rand loss can be carried over into the next year because it's still money that I need to recover, so to speak.
correct.
So my profit that I make in the following year is now going to sort of cover the loss that I made the previous year. So I actually then it cancels each other out. So if I make a 10,000 Rand profit the following year, then actually I end up breaking even because now my profit has covered the loss from the previous year. Is that kind of what you're
That's
saying?
that's right. Yes. So automatically you will then start with a minus 10,000, and then before you get taxed on that 28%. So only when you start making profit after you've covered that cost, you will then basically be taxed. So that's something nice with the incorporated company that can be carried over from year to year. And then
Okay.
also, one of the things that you need to consider is if your MOI is set up to be audited, then you have to have audited financial statements. So it's just important. Remember, on the previous sessions, we spoke about the short format MOI and the long format MOI. That's the rules and the regulations of the company. Now, within those regulations, you can stipulate if it needs to be audited or not. It's not compulsory, but there's certain requirements that you can bring in. So if in your MOI it stipulates that you must be audited, that might be an additional cost for the incorporated company. And then the other thing is that personal interest score that we spoke about, if that indicates that you need to have audited financial statements, that might also require you to have the statements being drawn up. And that can then basically incur the cost anything between 7.5 to 8,000 Rand, once again, depending on the amount of transactions that's going through the company. So if you look at the sole prop versus the incorporated company, the major thing I would say would be the tax bracket that you're going to fall into. And once again, with the sole prop, you can fall anything between 18 to 40,000, whereas with a company you'll be a flat rate of 28,000. But then obviously you can have that assessed loss that can be carried over, and there's certain benefits that you will have on that.
So I guess this is why I keep saying, like, I know that it's difficult to, when you're starting, you want to cut costs everywhere. But like, I see so many private practice owners do this where they invest their money in the fancy things like the assessments and things like that. You have actually all the clinical skills you need. You don't have to have a standardized assessment. You have all the clinical skills you need to do the assessments you need to do. So rather invest that money in an accountant who is also a tax specialist who you can consult with, because this just shows now how important it is to consider what your projections are or what your revenue is going to be as a sole prop, because at a certain point when it might be better for you to start off as a sole prop, because then you're only going to be paying the 18% on on your income. But the minute you hit that bracket where you're going to be paying more than 28%, then it might actually be better to have an ink. But then there's other things to consider as well, because I remember with my previous guest with Inora Accountants, like he spoke about how you can be clever in that, you in the ink, all your expenses are tax deductible. So you could run your because if you're using your mobile for your practice and it's also your personal mobile, that could be a personal expense. So you could actually cut down your personal expenses in your personal life through running it through your ink, which brings down, the profit, but then it's money that's you using anyway. And then so that whereas if you now, earn that amount in your personal capacity, you might end up putting yourself in a bracket that's where you're paying 40% tax. So
Exactly.
this is the amount that you're paying, that I know that people are shying away from saving costs by not wanting to pay an accountant. They could actually be saving maybe twice what they're paying an accountant in terms of what they're paying in tax, and just being smart in how they structure their expenses and their salaries and all of those things.
Absolutely. And once again, remember when we spoke about looking at different structures and how it's being set up, especially if you look at the longevity of of the business. If you sole prop and that's kind of where you want to stay, that's fine. But if you want to start growing and you maybe want to get partners in, or you want certain assets to be bought into a PTY Limited or into the Inc., and you maybe at a later stage want to get somebody else in, you don't have to redo all that paperwork or all that admin. And I think these are the small things that you can consider, and especially talking to somebody that is a tax specialist to help and guide you through that, to make the right decisions, to say, I'm fine, I'm going to stay a sole prop, or no, I think I'm actually growing, I'm touching on those 28%. Do I stay in my personal capacity, or is it actually better to now go into an incorporated company and just get the benefits of what you can get from there?
Absolutely.
Excellent. So then one of the other topics that you guys asked us about was actually winding up your entity. So that is when you're closing it down or you're no longer continuing on with it. So I'm just going to run you through some of the basics. So winding up or liquidating your company means that you decide that you no longer going to continue on with it. It's not working for you, and that's called a voluntary dissolvement. And that can be done either by the shareholders of the company making that decision, or actually creditors that can say, listen here, you are unable to make payment for dues, or for invoices or things like that. And they now are actually forcing you to actually just close the organization. So there is a section in the Companies Act that is guiding that. It's called Section 80 of the Companies Act. And that will basically give you the procedure that needs to be followed for a solvent company. So once again, the court can also determine if you need to be closed down as an organization or wind up in order to dissolve the company. And then also we're looking at a commercial solvency position. So that's something that we can maybe touch on a little bit later, to say what what does it look like to be solvent. So I don't know how many of you have spoken to accountants or auditors about a solvency certificate. So what it basically means is that you are able to cover your cost if there's any expenses in the company. So they would then basically give you a certificate or a letter to say that this company is solvent. So a lot of times what will happen is that if you've maybe bought quite big assets in the organization, if you look at the paperwork, it might not look as if you are solvent, but they will deem you to be solvent, because if you could sell the assets, you would be solvent. So that's one of the
Okay.
things that they will also look at when winding up the organization or closing it down, to say that you're no longer continuing on with it. Then what I've basically done is I've just given through a few tips on when to consider closing the business. So this will be specifically when you are restructuring the business to form part of the group. So remember we spoke about maybe combining a few organizations together. So Tasneem, I'm not quite sure if you guys can be interrelated in terms of the different organizations, or could it only be speech therapists that will bind together with speech therapists? Did they ever give you any guidelines in terms of that?
Yeah, so you can only be in an ink together as the same discipline, um, and you can only be in partnership with the same discipline. But what
Okay.
can happen is that um, my ink and your ink and the Speech Therapists Inc., we can form an association together.
Okay, perfect.
Or we can go into we can go together and form a PTY limited for the admin side and
Yes.
create like a rehab studio or kids therapy center, and then that is the PTY limited. But under that, we each operate as our own Inc. And then
Okay.
I can have my Inc. with different directors who are also OTs and under me employ OTs. And the other Inc. can be just her in her Inc. And the other Inc. can also be maybe partners, whatever our individual structures is, we operate independently. But then we also are directors of the PTY Limited, which is the admin function of the practice.
Great. And then sometimes what will happen is that people will also decide to streamline their business. So it might be that they have decided that they no longer need the incorporated company. They maybe just want to trade as a sole prop. They're scaling down a little bit and no longer want to continue. So that might be one of the considerations as well on closing down. And I kind of think in your industry that might be the probable situation for most of the guys in the organizations.
Yeah, and I think it's also like, so not everybody's building an asset that they're going to sell for lots of money. Or some people typically, I know with OTs, they tend to work like well beyond retirement age because they, I can't speak for the other professions. I just know in my profession, they tend to stick around for a long time. So they don't necessarily want to give up the entire practice, but like you say, they're winding down, going really, really part-time, only working when they really want to. So they want to now become a sole prop and, close off the ink and operate just when, as and when they feel like it. So that could be a kind of a situation of why you would want to wind down to a sole prop.
Absolutely. Then one of the other reasons why people will also consider closing down or winding down the entities is that they've become redundant or because there was a merger that took place, and then also if the company was probably registered for a specific purpose, so then maybe the project has lapsed or they're no longer continuing with it, and then they might also consider deregister or liquidating the company. And then what will basically happen is they decide as shareholders of the organization that they want to close down, and whatever the assets are in the organization will then be distributed to the shareholders. And that's basically what will then happen. So taking it further from there, when you decide to do a voluntary uh, dissolvement, sorry, I'm just going the wrong way now, is you have to apply with it with the master of the High Court. And once you've done the application with the master of the High Court and they are happy with that, that then basically moves over to CIPC. So CIPC is the governing organization where you initially registered the company, and they will then follow the last little bit of the procedure. So what will basically happen is the master will consider if you are able to wind out all your debts, and then they will ask a security that needs to be paid with the master within 12 months of winding up this entity. And then no further debts need to be furnished within that security. So you won't be able to then occur any further debt within the organization if you are proceeding with this instruction. So what will happen is that they will require a documentary proof from you guys to say that there's a sworn statement by the directors that they are authorized by the shareholders or the board to say that the company doesn't have any debt and that they now want to close it down. And then the auditor will also have to give a certificate confirming that the company doesn't have any debt. So after that procedure, then the master will then be satisfied and you can then continue with the process at CIPC. So we've got somebody in the office called Andre. He's a qualified attorney and he usually helps the clients through these procedures. So he will get all the documents together. They will draft the documents that's needed for the statements and give you the necessary examples so that the whole process will be so much smoother and so much quicker as well. So then they'll need the originally certified copies of the IDs of the directors, because remember, as we've spoken before, the directors' details are reflecting on CIPC, not necessarily the shareholders. In the case of an incorporated company, as we mentioned before, they will probably be the same people. The percentages might change slightly. So in this case, you will then have to supply the details of the directors. And then there's that COR 40.1 form. That's kind of like a special resolution drafted to say that you are winding up this entity and that you will no longer proceed with it. And then also written resolutions by the shareholders authorizing this transaction to take place and appointing the liquidator. So the liquidator will then basically be the person that's taking over control of that company once you have reached that point. And I think it's in one of the slides further on as well to say that once you have actually reached that point, that company is out of your hands and you can no longer proceed with that as well. So there's different ways of deciding where you want to be. Do you want to continue with the organization, or do you just want to close it as such? So then there's a form that needs to be submitted to the master, and that's called a Jm12 form that needs to be completed. So once again, the master of the High Court will then appoint the liquidator. There will be a notice in the Government Gazette, so that goes out publicly to everybody to inform them that you are following this procedure of liquidating the company. And then also there should be an affidavit then by the liquidator to say that no further interest was shown, to say that you're not allowed to proceed with the liquidation of the company. So the implications that you have for the company is basically that you will be prohibited to carrying on the business. And then, as I think I mentioned before, is once that liquidator has been appointed, the directors no longer have the power over the company. So the liquidator will then basically resume the power over that, and then winding up the operations and the proceedings for the liquidation of the company.
So let's say that you get to this stage, and so now you are Tasneem Abrams Inc. and you're closing the business down, but because you now want to continue just in your personal capacity as a sole prop, can you still use? Okay, let's not use Tasneem Abrams because that's your name, so obviously. But like, let's take my other company, Digital Engage, which is a PTY Limited. Say if I had to close Digital Engage PTY Limited because I now want to just kind of freelance, can I still then operate as the Digital Engage but without the PTY Limited and like under that name and that branding and all of that?
Yeah, you see, that's where it becomes tricky, because under the New Companies Act, they actually force you to only trade under the name if you've got the registered entity. So when it becomes a sole proprietor, you will probably have to trade under your own name and won't be able to use a company name as a type of a trading as, because you're not a registered entity anymore.
Okay. But you would still, I mean, like, how would that work in terms of like your branding and website? And would you still be able to operate as Digital Engage? It's just that from the point of view of like your invoicing and all of that, it's you.
It
Or
will
I
be
don't know.
you. I will what I'll do is I'll ask our trademark attorney that's involved with most of our trademarks as well, maybe to give us some clarity on that. I think that's a very good question, Tasneem, to say that if you have the registered entity and you're no longer proceeding with it, do you have a kind of a right to that name? Because I know with CIPC, where once you've gone into deregistration or liquidation process, you cannot register an entity with exactly that same name. So what we usually advise to the clients is, if they have gone through the process and they decide, but they maybe want to register a company with a similar name, that they maybe put the word SA or Cape Town or Western Cape or something like that as part of the name. But it would be very interesting to find out that if you close down the incorporated company, if you would actually be able to just trade under Tasneem Abrams in your personal capacity as a sole prop. I'll definitely make a note of that and maybe just find out from him.
Ilana, so Armand is here now.
Okay.
Should I add him
Yes,
to the stream.
let's add him to that.
Hi, Armand.
Good afternoon. Good afternoon.
Afternoon.
Great. So
how are you? Thank you for joining us.
Thank you for having me.
Armand, we've touched base a little bit on tax and also on winding up of the entities if you no longer continue on with that. But I think what we one of the things that Tasneem has also asked us was to actually talk about agreements and how that, as well as contracts, will actually influence organizations or sole proprietors when they operate as such. So that's before we're going to wind them up. Let's talk about that quickly. So, maybe if you can tell us a little bit about the shareholders agreement. Who could be involved in a shareholders agreement?
Okay, so obviously a shareholders agreement is, I would normally recommend having one if you are more than one shareholder. So for example, if you're a sole prop, you are operating under your own name. So you will not have a shareholders agreement because there's no a partner or additional shareholder or another member as part of the entity. So obviously, as a sole prop, you will not have a shareholders agreement. Only if you're, let's say, operating with more than one shareholder, I would definitely recommend that a shareholders agreement be put in place. So I'll explain as we go along. So the reason why we have a shareholders agreement, if you don't mind me jumping the gun, Ilana, is basically just simply put, there's a specific contract in place between all the shareholders that regulates the relationship. So that if something does go wrong, there's a piece of paper that goes, okay, but Ilana, you're responsible for this. You were in breach of that, and then I can enforce that legally. So it's a legally contractual contract, which is, however, very interesting is that a shareholders agreement, a lot of people think they have to register a shareholders agreement with the CIPC, like a MOI. But a shareholders agreement is a private contract, which means it is just between the two of us or the three of us or how many shareholders there are. However, it remains subject to the MOI and the Companies Act. So you cannot contract out of the law. So what that means is, let's say for argument's sake, the law says, like currently, you cannot register CCs anymore. And now the shareholder agreement stipulates, but listen here, if you become a shareholder, you confirm you will register CCs. This is a very stupid example. Then that provision is unenforceable because you're contracting outside of the law. So obviously it must be lawful at the end of the day, but it's a very important agreement to have in place. So it's kind of to make it as simple as possible. Would you rather pay, let's say, a couple of £1,000 for a proper shareholders agreement, or would you rather have a big court case to fight about shareholding that costs you a couple of £100,000? So it's kind of quite an easy sum to make at the end of the day.
Okay.
So I can maybe give an example from what I understood you to say that's very applicable to our situation with health professions, because we have to abide by the Health Professions Council's ethical rules. So I suppose an example of that would be you can't then have in your shareholders agreement that I will always refer all my patients only to you. So say I specialize in working with teens and you specialize in working with kids under 10, and this parent that I'm speaking to, her younger child also has a problem, and the agreement can't state that I will only refer to you because that's ethically not allowed by the Health Professions Council. So you can't contravene that in your shareholders agreement. You have to have some other way of making sure that the business is there for everyone and not stipulate that you will only refer to that particular therapist.
Yeah, no, definitely. And also at the end of the day is, let's say that the person you want to refer them to, they are most likely not the party to that agreement because it's only between you and your fellow shareholders. So they're not privy to the information contained in that. And as you mentioned, it will be contracting outside of the law because specific to your industry, you have a code of conduct, a code of ethics that regulates certain actions that you are allowed to partake in and stuff like that. So obviously, once again, it will then be bad in law and, for example, it won't meet the requirements of a valid contract because it's not you can't basically live it out because it's contrary to your own code of conduct, which you are subject to at the end of the day. Yeah, that's very important. Also, when it comes to shareholder agreement, to make sure it is particular to the operation and the management of the company. I'll explain later on what kind of stuff is generally contained in a shareholders agreement, but ultimately, what I always try to explain to clients who doesn't understand the legalities behind it is either spend a couple of $1,000 now or spend a couple of $100,000 later if everything goes sour. Because remember, if you want to go and, let's say, you don't have a shareholders agreement in place, I cannot force you to sell your shares. I have to eventually take you to court because you have no written agreement says if this happens, you sell your shares so and so. So if you don't want to play ball, I basically have to take you to court, and that means, attorneys, possibly advocates, spending days or hours in the court. Those are massive legal bills that's racking up, can take years to resolve, and then you'll know further than you started off with. So after 2 years, you can easily sit with a $500,000 legal bill because you felt it's not necessary to spend, let's say, 5,000 Rand on a proper shareholders agreement. So I also have to explain it like that, just to maybe make it more rands and sense orientated, just to stick a little bit more.
And Armand, if you have to give them some guidance as to how you would set up a shareholders agreement, where would you start with something like that?
Okay, so where I would start with something like that is, number one is to have, let's say, informal discussion amongst all the shareholders, just to confirm who's going to be responsible for what. Is there anything specific they want to add to the shareholders agreement? Do they want to regulate how shares are transferred, how it's sold, and stuff like that? Because there has to be some consensus in the beginning to make sure, obviously, everything is there is agreement among the parties. So you don't want to go in and one party goes, okay, I'm going to pay Armand to do a shareholders agreement, and then they come back to the other shareholders and go, look here, guys, this is what is sold up, and everyone's like, no, but we never spoke about this. I'm not going to sign this, or I do not agree to it. It's back to the drawing board, have it amended, pay some more money. So at the end of the day, it's not effective. But generally, what I would say to include in the shareholder agreement is obviously, number one, very important, the share structures. So basically, Ilana has 50 Class A shares or ordinary shares. Tasnima has 25 ordinary shares. Armand has 25 ordinary shares. And the voting rights are equal to the amount of shares. Or, for example, there's a different share structure, let's say Class A, B, and C. So you have your ordinary, your preference, and let's say employee share scheme. And obviously, it sets out the structure. Then also what's very important is, for example, a forced sales provision. So that is where if a certain set of criteria is met, then you are forced to sell your shares. So let's say, for argument's sake, that you are a director and a shareholder and an employee. Because I don't know if you addressed this previously, Lana, but basically each relationship has its own responsibilities and own method to get rid of that person. So let's say, for argument's sake, in your shareholder agreement, you stipulate there that a shareholder must at all times be a director of the company. And if you fail to be a director because of X, Y, and Z reason, let's say insolvency, death, whatever the case would be, then that provision triggers, which means within 30 days you have to sell your shares subject to X, Y, and Z. Or, for example,
Sorry, Armand, if I can stop you there. So, Tasneem, what's really interesting, what Armand has touched now on as well, is that maybe if you're in an incorporated company, as you guys should be, then maybe somebody dies, and then according to the will, that company is now being transferred to their wife. Now, them not being the practitioner, that actually leaves quite a big situation for you guys. So that might be something that you can actually stipulate in the shareholders agreement as well, to say that if somebody within the organization cannot fulfill the role anymore, or in the event of death, this is how you will compensate either the spouse, or buy them out, or get an agreement over 5 years to pay off that money. But I mean, these are the crucial things that needs to be stipulated, and you don't necessarily want to put all that detail into your MOI. But once again, it can be the type of detail that you can include in a shareholders agreement to say, according to us as shareholders, this is what we agree upon should somebody not be able to fulfill the position. Sorry, Armand, you can
again of how it needs to be compliant with the rules, because again with the HPCSA rules, a non-health, not even a non-health professional, but a non-same discipline cannot be like a director in, say, a non-OT can't be a director in an OT practice, because then they would be automatically responsible as an employer of other OTs, which they're not allowed to do. So exactly like you're saying, if the fellow OT director had to die or move away or whatever, then that needs to be thought of in the shareholders agreement about what they're going to do with that particular director's shares.
No, no, definitely. A lot of professional industries, like you mentioned, the healthcare, attorneys, engineers, CAs, all this type of stuff, they obviously have very rigid rules that stipulate, listen here, I cannot come in as an engineer and be a director of a chartered accountant's firm, for argument's sake, because we're not on the same discipline. So obviously you want to prevent situations like that, because if there's nothing in writing, then obviously there's no terms and conditions regards to the share. So basically then you're going to have to try to negotiate, say, to the executor or to the wife or whatever the case may be, so listen here, we'll offer you X, Y, and Z for the shares. Now, if you have a shareholders agreement, you can stipulate the terms of what happens. Also, you can the valuation method that has to be applied, all the different type of stuff. Or, for example, even the sequence of how the money would be paid if you do buy out the shares. So listen here, we're first going to use this to settle this, then do that, and whatever the case may be. There's a lot of other important stuff as well, and very technical clauses like tag-alongs and put and call options and come-along clauses. But I would definitely say what's also very important is, number one, to make sure there's a dispute resolution clause. So that will basically govern if there's a dispute about the terms and conditions in the shareholders agreement, that there's certain steps to follow. So, for example, Ilana concludes an ordinary resolution without the approval of Tasneem and myself. We feel that's in breach of the shareholders agreement. We issue over notice. She has 7 days to rectify it. It doesn't work. Then instead of going to court to enforce that, then our agreement will stipulate we will basically get an arbitrator. So it is a little bit more cost effective, it's a lot quicker as well, and it's a binding award which can be made in order of the court. So obviously that's great. And you also stipulate there, if there's a deadlock, who has the swing vote. All those different type of stuff. So I've seen a shareholders agreement where the parties are 50-50, but because the one party brought the goodwill to the company in terms of bringing under his label and his brand, he basically has any swing vote when it comes to anything that affects the brand as a whole. So anything that affects the brand, he then has a final say if there's no consensus at the end of the day. So yeah, shareholders agreement, you can put a lot in there. It is a private contract, like I mentioned, at the end of the day. But yeah, let's maybe go to the benefits. That is very important once again, because it kind of is a culmination of what I mentioned earlier. Is it creates clear responsibilities and procedures for the shareholders in terms of their rights and powers. Now that is very important, because if there's nothing in writing, once again, you're not going to know, okay, but who's responsible for that? What do I do? Okay, I have to spend an extra amount of money to enforce this and X, Y, and Z. So you want to know exactly, okay, Tasneem, she brought in so much capital, she has so much shares, so voting rights, X, Y, and Z. If she does divorce, whatever the case may be, then she's no longer part of the Inc. or whatever the case may be. Obviously, it's almost legally enforceable, but you want to make that clear, because you don't want to have a relationship that is unclear and is gray areas, because then someone might, let's say, bite it out, they might abuse it. It might result in a long-winded dispute resolution procedure. It might end up in court, which is unnecessary in this day and age of all alternative dispute resolution methods and avenues. So ultimately, it makes it simpler, more cost-effective, and it's easier to enforce at the end of the day. So it's just ultimately, it makes no sense to me why not to have one, unless you're obviously the only shareholder. But you want to have something like that in place to make sure everything is in order.
Yeah,
so on that question, on the topic where you said, obviously, if you start an Inc. and you are the only person in the Inc., so you're the director and 100% shareholder, then you obviously don't need one. But then, where a good time is when you are considering bringing in another director and shareholder into your Inc. Is that when you kind of have to now do a shareholders agreement, and do you then have to think about only that one additional person, or do you think like, okay, if I'm planning to bring in another 2 people over the next 5 years, do I now already create that shareholders agreement?
Yeah, so I would definitely say you kind of want to swing both ways, in the sense of you want to future-proof it against future situations where you bring in more people, but at the same time also include any provisions applicable to that specific director. So, for example, you would have a case where, let's say the agreement is that director only gets, that shareholder only gets 10% of the shares. However, over the next 5 years, if they perform and meets X, Y, and Z KPI, you will provide them with 1% of your shareholding each year, for argument's sake. But it's also very important, that has to be remembered, is if the new shareholders do not sign that agreement and agree to that agreement, they are not bound by it. So it's very important that prior to any shares being sold, obviously excluding the sale of shares agreement, transfer certificates and stuff like that, is that they actually agree and sign a shareholders agreement so they can be bound by it. That's very important at the end of the day. But yeah, I would definitely say you want to kind of like future-proof it, or in the very least to update it every couple of years. If it's just the two of you, and you maybe like after 3 years you go, but let's maybe consider additional shareholder because we want to expand the practice, or we want to get another specialist in that's going to basically take the workload off it. We kind of want to incentivize them by being a shareholder of the company as well to get like profit share, whatever the case may be. So I would definitely recommend to kind of do a little bit of both, because you want to create that framework for the future just to make it easier.
Yeah, the other thing that you can also consider, Tasneem, especially when you look at shareholders agreements, are things like the rights of selling the shares. So maybe within that shareholders agreement, you can then stipulate that the right of selling the shares, you first want the shareholder to give you the option to buy the shares, then selling that off to somebody else. So these are the type of things to kind of like prevent a hostile takeover or something like that of an incorporated company, is to make sure that there's maybe some rules and regulations stipulated within the shareholders agreement that will give guidance as to how and when shares will be sold.
Okay.
Great. Anything else that you think of that you maybe want to touch on shareholders agreements, or can we go over to the contracts?
No, I think we can continue. Yes.
Lots of information flying here today. Great. So maybe you can maybe stipulate. I mean, we've spoken about contracts and the importance of looking at contracts when you sign a contract as a sole proprietor or as an incorporated company. And I think we spoke about that today in the office as well. So why would it be important, and what is a contract?
Okay, so let's maybe start just off with what is a contract, and then we can move over to the sole prop versus the Inc. So obviously, I think there's a lot of misconception regarding contracts. So people think a contract is that thick piece of paper that the attorney hands you to sign on every page with a fancy pen in the fancy office while drinking a cappuccino. So obviously, a contract many different forms. Now, if you go to the shop and you buy a bottle of Coke, that's a contract. If you go to the aquarium or you buy a new house and stuff like that, there's a contract involved. So a contract is not always in black and white. It can be tacit, it can be implied. And obviously by law, there's certain requirements that a contract must be in writing. Let's say like you're selling a house, it has to be in writing. There's no way around it. However, we can agree now verbally to, for example, me buying 10% of Tasneem's business for R1,000 for argument's sake. You understand? A verbal contract is also enforceable as long as it meets the requirements of a contract. So a contract, there must be consensus. So meaning we have to have agreement about what we're going to sell and how we're going to sell at the price and everything like that. So I'm not going to go into too much depth in terms of the various aspects, different forms of contract, different essentials as they call it. But basically, there has to be consensus. You have to have capacity. So a 7-year-old cannot sign a contract to buy a house. So they don't have the legal capacity to do that. Obviously, the guardian can do that on their behalf. Capacity is also, for example, you are under the influence of drugs or alcohol. You are mentally unstable, mentally unfit, all this different type of stuff. Then there has to be certain formalities. So where it's agreed that the formality is the contract must be in writing, obviously the contract must be put in writing, but there's no agreement on the formalities, and the contract can be oral, it can be via SMS, WhatsApp, email, whatever the case may be. Then obviously the contract must be legally enforceable and you must be able to perform the contract. So for example, if we conclude a written agreement that I will be a hitman for you and I will shoot X, Y, and Z, that is not legally possible, legally enforceable. Even it can be in writing, can be very pretty, can have stamps and everything like that, but it's not legally enforceable at the end of the day. So that contract is worth nothing, basically. Then obviously there must be actually the intention of the parties to perform in terms of that contract. So it's all good and well you sign, but there must be actual intention behind the parties to sign. And that's where the consensus part also comes in. So the big difference when it comes to sole props versus inks when it comes to contract is, I think when it comes to liability, that's going to be the biggest thing in my opinion. So a sole prop, obviously you and your business are one and the same. meaning that anything that goes wrong in your business, you as a person are responsible for that. So if your business racks up 100,000 rand of debt and your business cannot pay it, they will come after you into your personal capacity to get your assets. Whereas the incorporated, the difference is there. Obviously, the liability is separated, but if you catch on nonsense in terms of signing a contract without reading it, without the fine print and stuff like that, then they can obviously keep you and your fellow directors jointly and severally liable. So meaning you can actually put everyone in jeopardy that was ever a director or a shareholder of that company at the end of the day through your signature, because the Inc. obviously, because of the professional association of individuals like attorneys, OTs and stuff like that, obviously everyone is liable for what happens because you have to take obviously personal pride, ethics and all this type of stuff. So basically the biggest difference in my opinion was where you sign under Inc., you must be 100% sure what you're signing, why you're signing, what's terms and conditions, because otherwise you might be caught at the end of the day by getting everyone else in the firm being held accountable because of you didn't read the clause that stipulates you must pay 50% interest on X, Y, and Z every time you open up an account at Walton's or whatever the case may be. So you have to be very careful when it comes to that. So definitely liability, I would say, is the biggest difference between those two.
Yeah, interesting enough, I know this doesn't have to do with contracts, but even when we appoint directors on a company and one of them are blacklisted, then you can appoint them via CIPC because, I mean, they don't check if you're blacklisted, but then you get to the bank and this person is blacklisted, then the banks will actually force you to first resign that person before they will open a bank account. So
Okay.
exactly as I said, there's certain liabilities that you have to consider when operating, and signing an opening of a bank account might actually be seen as a contract as well. So it's looking at those type of things just to say that you need to know what you are signing for and who you are placing in jeopardy by doing that.
Okay.
No, definitely. Yeah, so once again, it's very important to make sure, obviously, because liability, remember professional liability insurance and stuff like that will only cover you so far. And obviously by signing contracts, you never know if you don't actually read the contract. There's so much stuff you can shoot yourself in the foot. Just imagine from a day-to-day option, how many times you actually go on a website and you just go click accept terms and conditions. You understand?
Yeah.
That action might keep you liable. You understand? So that is very important that you actually go and read your contracts, especially if you're in the capacity of a director or a shareholder and you're signing a contract on behalf of your company. You have to make sure that you actually sign, because not only is there liability in terms of the contract, but if you do not perform in terms of your duties in terms of the Companies Act, you could be held liable in that sense as well and never be allowed to be a director ever again. You understand? On any form of company. So it's very important to make sure you actually read. And just maybe an insider tip, if I draft a contract and I want to be really, let's call it naughty and catch you out, I would put in, to catch you out, I would change the definitions. I would put a definition clause in a contract and I would put a certain definition there, because the explanation of this definition I will expand on. So let's say for argument's sake, I say every Monday you will be paid in the contract. And under the definitions clause, I would say Monday, which means any day between Monday and Sunday. You know, so
Yeah.
small little way to kind of catch out people. So I always thought that in the beginning, when I started working in the legal industry like this, always make sure about the definitions, because legal definitions and the factual definitions we have in a day-to-day life does not have the same meaning. So that's very important that people just read the contracts, read the definition, and application and all this type of stuff. So that's very important. Then a lot of people go like, but a breach of contract, what does that look like? Because a lot of people think, oh, I did not do what I was supposed to do into the contract, that's a breach. That might be so, but there's different ways to actually breach a contract. I just want to give you a couple of examples. So you get, for example, a positive malperformance. Now, positive malperformance is, they said the agreement is, Tasneem, I have to give you 10 apples. I have to sell you 10 apples. But it has to be 10 green apples. So I bring you the apples, but it's 7 red apples. That is positive malperformance in the sense that I performed, but I didn't perform as contracted. That is in a breach of the contract. Then you obviously also get mora creditoris. So that is where the cooperation is necessary of the creditor in terms of performing. So, as if for argument's sake, the creditor is supposed to open the gate at 8 o'clock so the plumber can come in to fix the shower, whatever the case may be. If the creditor then refuses to open up or doesn't open up, then obviously they have committed a breach because they don't adhere to their side of the story. And then something that a lot of people do is they kind of what they call repudiation. So that is basically where, without any form of legal excuse, they just kind of say, I'm not bound by this contract, I'm not going to adhere to it, I disregard it. So a very simple example of that is in the employment relationship where the employee goes, they just disappear, they abscond, they desert. They kind of repudiate the contract through their actions because they have no legal excuse. They just decided, I'm not going to give notice, I'm not going to resign, I'm just going to go work somewhere else, or I'm going to run away because they want to fire me, or whatever the case may be. That's kind of repudiation at the end of the day. So those are just a couple of examples of what a legal breach looks like. Obviously, practically, it has many different faces. Can be from not delivering the right product to a broken product to, for example, delivering late, not on time, and so forth, or not paying the right amount, paying late, and so forth.
Okay. It's funny that you bring up the definitions because just this morning I was looking at a partner agreement between Private Practice Growth Inc. and another organization. And obviously in the beginning is the definition of terms. And I'm just laughing now because I kind of skimmed through it because it was like, oh, well, it's obvious what all of these things mean. So now I'm going to make sure that I read it properly.
No, definitely. That's very important. Like I said, if you really want to be, let's call it naughty for lack of a better word, that is kind of where you would catch people out. So a lot of times they say, but lawyers use a lot of legalese, so unnecessary large legal jargon. But actually, if you want to write decent contracts, you must actually write it for the person that's intended to sign it. So there's no point for me to write it a 20-page employment contract if I'm going to employ a receptionist at a what's this stupid example? They say the printing store. It's not a complex nature of work. So I'm actually just kind of making things more difficult because she or he will not understand that contract at the end of the day. So you also want to write contracts for the people it's intended to. And that's a very important principle. Very few people actually apply because they want to kind of show off their legal knowledge or their massive words and stuff like that. And granted, it has this application. But I'm definitely a big fan of trying to write a contract specific to situation and also in simple enough terms that your average person can understand it.
Yeah, I think Armand, if I can jump in there, I think the reality for me is that a lot of times people will, I think we spoke about this earlier as well, is just not spend money on things like getting somebody to draw a contract. And I think that's sometimes what happens is they'll find something on Google and they think that would be applicable to them and not understanding the implications if there's a clause or maybe like you said, the definition that's not applicable to them, and then using that in a contract, and when it goes to court, then they've got bigger problems. So I think, Tasneem, I think you mentioned about seeing an accountant or getting somebody to look at your taxes. So we all want to save the money, but sometimes that can come back and it can have bigger implications for one.
Yeah.
No, definitely. So, please do not download contracts from Google. A lot of people don't actually look at what the download is. They say, oh, employment contract. Meanwhile, it's applicable to the state of Mississippi in America. So our labor laws are completely different. So I've seen it time and time again. I've seen, you get these horrible contracts online that have provisions in there that's not even legally enforceable and stuff like that. So I know it's cost effective. A lot of people kind of squirm at having to pay someone to draw up a contract because they don't see the true value in it. But it's kind of like spend a couple of $1,000 or a couple of $100 now, or spend time, stress, energy, and a couple of $100,000 later in court. So it's kind of at the end of the day it's the lesser of two evils, if I can put it bluntly, in terms of that. So maybe just in terms of remedies, in terms of contracts. So obviously, when there's a breach, you get different form of remedies. So remedies is more like the legal terms of what you're allowed to do in the situations. So obviously, you can, number one, keep the contract intact as is and just sue for damages. So for example, Tasneem, let's say you go back to the apple example. You say, listen, Armand, okay, now I still want the green apples, but because I lost a contract with whatever company because of your performance, I'm going to sue you for damages because of that contract. Then, for example, you also get a cancellation. Say, listen, Armand, I'm not going to accept it. I'm canceling the contract. And then obviously you can also combine the different parts of the contracts as well, in terms of cancelling and suing for damages, or keeping the contract and suing for damages, and so forth. So there's predominantly those are like the main kind of remedies, is like cancelling, suing for damages, and so forth. So yeah, it's very important that you kind of know these stuff, not necessarily know it in depth, but you need to know in which direction to move, so you know where to get the information if something does happen. Because if you do not know, okay, but there's kind of like a breach in a contract, you might be taken for a ride, and you might actually lose out on a legal claim, because the law also considers a certain legal claim without any force if you knew about it, but you didn't do anything about it for a certain time frame. So then the law goes kind of like, okay, but you're not concerned about it, why must we be concerned about it? So they call that prescription. So obviously I'm putting it very simply. It's obviously a lot more complex than that, but it's just important to obviously just note these small little things at the end of the day, and just be careful of when you do research stuff online. Make sure you're reading it from some African sources, because our legal system is a hybrid system compared to America, France, Australia, wherever the case may be. So our laws are not the same. We do apply conventions that's applicable across the globe, but in terms of our actual day-to-day laws, just please be very careful when you do go and read up or Google something or whatever the case may be. Always look for that .co.za, or in South Africa this was found, or whatever the case is. Just be very careful in terms of that. But yeah,
just to make it practical for Tasneem and them as well. I mean, there's no limit as to how short or how long a contract should be. So, Tasneem, do you guys ever have forms that you get a client to sign up front, kind of confirming the information and saying that if they can't pay, or if the medical aid can't pay, then they would be held liable for the...
Yes. So yeah, so the three, in fact, you shouldn't be practicing without the three main forms. The one is informed clinical consent. So you shouldn't touch a patient or even observe a patient without them consenting to treatment. So they need to sign that informed clinical consent. So the person who's going to treat them needs to explain what the treatment or assessment that you are going to perform, and then they need to agree to it. Then there's the informed financial consent. That needs to stipulate how you're going to charge, like what your terms are, cancellation, all of those things. They need to be made aware of. And then the third one, which is only applicable if you actually do telehealth, which is informed telehealth consent. So people who are practicing without having at least the informed financial and clinical consent, they're actually not practicing ethically, because that is a fundamental necessity before you treat the patient. I did have Elsie Klink from Elsie Klink and Associates, who's a specialized health law consultant, and she does actually sell kind of custom contracts specifically around the clinical forms that we need. There's all kinds of forms. It's also like if you're dealing with children, if you're dealing with schools, there's the POPI forms, there's all of those kind of forms that we need to consider. So it's quite a lot.
Yeah. So the reason why I'm asking this is because a lot of times we think of forms not being a contract, but if there's two people on that form, and one needs to deliver something and the other person needs to accept that's a contract.
Yeah,
and definitely, especially with the forms relating to, let's call it, health and very confidential information or very sensitive information, and all the consequences of not having, let's say, the POPI form or the financial consent or the clinical consent. It has much more dire consequences than, for example, if I sell fruit next to the road and I do not have a finance form. You understand? Because obviously the nature of your work is high risk. If you do something wrong, they will sue you, they will do X, Y, and Z, because it's a high emotional, high risk type of situation, because you're dealing with health, you're dealing with people with their mental condition, their physical condition, and stuff like that. So it's very important that the proper legal documentation is put in place. You have your proper insurance in place, you're a member in good standing with the Healthcare Council, all those type of stuff, that if you are caught in a bad spot, you obviously do have some defense, if I can put it like that, because now you don't have the proper form in place where you consent to me giving your information to Discovery Health to make sure I can claim against your account for argument's sake, or processing your personal information. The information regulator comes and they kind of fine you hundreds of thousands of rand or millions of rands, or send you to jail, or whatever the case. Obviously, that's a over-exaggerated example, but you want to have that stuff in place. But just maybe I can just touch on another slide you did about the insolvency and the liquidation. What's also very important in a situation is, when it also ties to contracts, is you have to have your proper employment contracts in place as well. Your proper employment policies. So that all of this kind of ties in at the end of the day, because your rights and powers kind of stems from contracts at the end of the day. And when it comes to like liquidations and stuff like that, a lot of people actually forget about their staff. They think they just go, cool, I'm liquidating, cheers, goodbye. You understand? But there's certain laws that actually apply where the staff are entitled to certain things. They can apply to their estate for certain reimbursements, all this type of stuff. They have certain entitlements, and you have certain liabilities at the end of the day. So I'm a specialization. I'm a labor law specialist. So I have dealt with companies that's closed down and liquidated, and they had staff at the end of the day. So there's certain procedures you have to follow, and you can really be nailed hard if you do not follow those procedures correctly, or if your contracts are not handled correctly or not drawn up correctly, and there's the consequences. So once again, it's very important that even for a small business, even if you have just one staff member, make sure you have something in place, even if it's just a basic contract which you paid for 490 rand, whatever the case may be. Make sure you have a proper employment contract in place, because that will have a snowball effect on the rest of the legalities, costs, stress, and everything like that. So it's very important that everyone understands that contracts not only between its shareholders or directors, or the company and the shareholders, also between the company and its staff. And that's crucial. I've realized a lot of small businesses kind of ignore that because, I'm too small, nothing will happen. But I have had sole props of one staff member who got an arbitration award of 6 months awarded against them, because they simply didn't believe they have to apply any labor law, because it's just one employee, I don't have to care about that. But the law doesn't differentiate on some of the big parts when it comes to the amount of staff. It's about the definition of being an employee, which is the main criteria. So it's just, if I can leave maybe a final thought, is just make sure that the employment contracts are up to date, they are decent, and they obviously protect you as much as they protect the employee as well at the end of the day.
And I think also, like, earlier, Alana, we were talking about having, so because we have to be registered as an Inc., but we were talking about how as allied, as multidisciplined, you can have a PTY limited for the administrative functions, and then each one operates as an Inc. underneath. Surely there needs to be that contract between the PTY limited and each individual Inc. that's now kind of also directors in the PTY limited. There needs to be some kind of business contracts around how that relationship works, and if one Inc. decides to move off and not participate in the PTY limited anymore, and all of those kind of things.
Yeah, absolutely. Tasneem, you touch base there on something really important, because a lot of times we kind of say, okay, we'll still get there, or we'll still work it out, or whatever. But then it might be too late. So it's better to kind of talk about these things, get it in writing, and get something that everybody agrees to, because to try and sort it out later, and then we can't remember what did we actually agree upon, and things like that. So it's definitely advisable to, if you start growing the organization from being a sole prop to becoming a incorporated company, and getting structures in place of maybe a PTY limited, it's really advisable to rather cover yourself and make sure that you've got the right paperwork in place, that it's clear to everybody what is required, and if for some reason you don't want to continue, what is the procedure to follow, because you don't want to get into that situation we are unsure, and now suddenly you have to pay out somebody, and that wasn't the initial agreement.
So besides the company registration, that is, all of those things are all aspects that company partners can assist with. The setting up contracts, agreements, shareholder agreements, winding down company, all of the different stages in the business's growth. Those are all kinds of services that you guys can assist with.
From the start up to the finish, but we're going to try to keep you active all the way.
So, I just want to end off by saying that this is all health professionals are not to like having these kind of very business oriented kind of talking, and a lot of my audience are maybe people who are just thinking of starting or have just started. So it might seem like why do I need to know all these things? But I get messaged quite a lot, and there's often people who say, I've just come out of like a really terrible partnership. It was extremely messy. And now they like kind of want to go, they're starting over. They've now just come out of that. They're starting over. And that just reminds me like why this is important. This is part of the reason why I'm bringing this kind of like very high level business stuff in, because people don't realize now you're starting off and you think you don't need it. And then you get into a partnership or whatever, you register your business incorrectly or whatever, and you really end up in this really nasty, toxic situation where you didn't have those agreements in place, and now you're not getting along or whatever the case may be, and it's really not a great situation to be in, aside from the monetary cost. Just being how stressful that is, like to be in that situation. So that is why it's so important to kind of educate yourself around these business things and know who can you reach out to if you're not kind of want to sit down with agreements and that. Who can you go to say, sit down with me and explain this and make sure I'm look after my needs for me, so that you can have peace of mind that going, as your practice grows, that you're not going to get yourself into these tricky situations.
Absolutely. And even the fact that, as you mentioned now, maybe somebody else that you're going into agreement is giving you the contract and you're unsure if there's anything that you should look out for, like Armand has mentioned the definitions. Maybe it's just good to have that second opinion.
Yeah, absolutely.
I just interject there. So you do actually get a very or you do get reputable consultancy firms which you can actually sign up for a retainer, and they actually offer you, let's say, labor law advice or legal advice, stuff like that. So it's always highly recommended to it where, for example, you start a business. Let's say your labor starts ticking off. You have, let's say, 3 therapists, 2 receptions lady, a finance lady, whatever the case may be. Then get that support through a professional body, because at the end of the day is you need to focus on your passion. You need to focus on building your business and your own particular skill set, and then outsource your weaknesses. So if listen, your passion is not great, or I always lose my temper when I speak to staff, so I have to get someone to deal with it, then outsource that. Don't put your foot in your mouth and end up chasing someone away verbally, and you go to the CCM and you pay 12 months salary because you were too stubborn to pay 600 Rand a month to get a retainer agreement with a reputable law firm on their smallest package, or whatever the case may be.
Yes,
so I do know firms that actually does, for example, the legal consulting on a retainer. So it's not difficult to come across stuff like that. I would just say, just make sure it's a reputable firm. I'm not going to mention names, but just make sure it's reputable, and build that relationship so that you actually have that person go, listen here, PT or whatever his name is, I'm trying to think of this, what happens, or get like a proper business coach. So I actually know hematologists that actually got in a business coach once a week just to sit with them, the 2 main directors and shareholders, just to kind of guide them, because they want to focus on their practice and the people management and the legal side and the frameworks and the structures and all this other stuff. They want to kind of get guidance on, because that's not their forte. They want to help people. They want to, solve medical issues. So outsource your weaknesses at the end of the day. Do not sit there and wonder, okay, how am I going to do this? Get someone to do it for you.
Yeah, absolutely. Thank you so much to both of you for your time, and definitely looking forward to hearing feedback and what questions. We won't have time for the other question I had. I was asking Ilana about non-profit companies, because health professionals, being as they are, they always want to do free work. And that's a question that has come up a lot about like opting pro bono and what is the option if you want to have an NPC and so on. But I think we will leave that for the new year. So thank you once again, both of you. And it was nice meeting you as well, Armand. And I hope that you will take up the offer to come and see you for assistance with these kind of issues.
Excellent. 100%. Thank you, Christine. Thanks, Armand.
Thank you.
Bye.
Rap.